Okay, so we've got 2 more sessions to go for today. Just before I hand over to the next speaker, I just want to let you know there's evaluation forms on your chairs and tables. If you could please fill them out, they're really helpful for us when we organise these forums. We want to make sure these forums are as relevant as possible. So please fill them out and leave them outside on the table before you leave. So I would like to introduce our next speaker, Sharon Kutrali, the Medical Decision Support Officer from the Office of the Public Advocate. And she'll be talking about changes to the Medical Treatment and Planning Decisions Act, Powers of Attorney Act, and flag changes to the Guardianship and Administration Act. Welcome.
Thanks, everybody. Thanks, Melissa. Just to clarify, hang on. Okay, so what I'm going to be talking about today is the Medical Treatment Planning Decisions Act of 2016, the Powers of Attorney Act of 2014, and I will be talking about the Guardianship Administration Act of 1986. I won't be talking about the Guardianship Administration Bill that's currently before Parliament because it hasn't been passed. So until that gets passed, there may be a lot of amendments, a lot of changes, and it may actually go back for redrafting, so it's not appropriate to talk about that. So today in my presentation, I'm going to talk about these 3 acts of legislation in respect to decision-making capacity, supported decision-making and substitute decision-making. So as we all know, Article 12 of the United Nations Convention of the Rights of Persons with Disability recognises the rights of people with disability to enjoy legal capacity on an equal basis with others in all aspects of life. This is a recognition of a person's right to make decisions. Signatories of the United Nations Convention have agreed to move away from the regimes of substituted decision-making towards regimes of supported decision-making. So first of all, I'll cover decision-making capacity. A person is said to have decision-making capacity to make a decision if they are able to understand the information relevant to the decision and the effect of the decision, retain the information to the extent necessary to make that decision, use or weigh up that information as part of the process of making the decision, communicate their decision in some way, including speech, gesture or other means. Now, these slides will be available, and I've got some publications from the office out in the foyer as well, so please don't feel pressured to write things down. Now, adults are presumed to have decision-making capacity unless there is evidence to the contrary, so we all have a right to make our own decisions free of undue influence. A person who is assessing another person's decision-making capacity should take reasonable steps to conduct the assessment at a time and in an environment in which the person's decision-making capacity can be most accurately assessed. I'm sure this isn't new to any of you. So as I said, there's a movement now away from substituted decision-making. An individual's decision-making capacity should never be assumed based on their appearance or on a diagnosis. Decision-making capacity is decision-specific. In Victoria, we have 2 competing approaches as to how people who have difficulties making decisions are treated. There's the substitute decision-making approach and the supported decision-making approach. Victoria has incorporated both substitute decision-making and supported decision-making into its legislation. So substitute decision-making includes the medical treatment decision-maker, an enduring power of attorney appointment or guardianship and administration order. Supported decision-making currently includes a support person, a supportive attorney or a nominated person. Decision-making arrangements for persons with disabilities takes many forms. Some are informal arrangements, such as having family members or friends involved. The formal arrangements can be divided into 2 groups. One is a formal preemptive arrangement, where an individual is anticipating future loss of capacity through the appointment of a proxy. For example, this might be an enduring power of attorney or an advanced care directive under the new Medical Treatment Planning Decisions Act legislation. A more formal arrangement is where a tribunal, such as VCAT, appoints a person to make decisions on an individual's behalf, and that's where the guardianship and administration orders come into play. Substituted decision-making enables a proxy to make decisions on behalf of another person who is incapable, for whatever reason, to make that decision. But there is a growing concern that this goes against the fundamental freedom and protections of human rights. That's why we're strongly focusing more towards supported decision-making. Okay, so in Victoria there's a significant shift away from a best interest model of decision-making in favour of promoting the will, values and preferences of individuals, and there are a number of laws that enable people with cognitive disabilities to appoint or nominate someone to assist them to make these decisions. The laws that operate, as I said, is the Medical Treatment Planning Decisions Act of 2016, the Powers of Attorney Act of 2014 and the Mental Health Act of 2014. Substituted decision-making has traditionally been based on a best interest model, while supportive decision-making gives full consideration to the individual's wishes, values and preferences. So the law says that a person is able to make a decision with support, then they have decision-making capacity for that decision. So decision-making capacity, as I said before, is decision-specific. So support may include the additional time that it takes for an individual to make that decision. It may include someone to help them in discussing that decision, someone to assist them to communicate the decision, technology, or modified language and visual aids. Supporting an individual to exercise their legal capacity through practical assistance leads to self-determination and personhood. Okay. So the legal roles for decision supporters. Supported decision-making is assisting the person with disability to make their own decisions, make choices about their lives and exercise control over things that are very important to them. Roles for decision supporters are under these legislations would be a support person under the Medical Treatment Planning Decisions Act, a supportive attorney appointment under the Powers of Attorney Act, and a nominated person under the Mental Health Act of 2014. As a supporter, legal recognition gives authority to the support person to advocate alongside the individual who is making the decision by creating decision opportunities, exploring their wills and preference, and implementing their decisions where necessary. It can also resolve problems where there's concerns around privacy and information sharing. So these appointments, having formal and legal authority, can assist when an individual needs to interact with hospitals, banks, Centrelink, utility providers, etc. Well, that's the aim. Okay. So the first legislation I'm going to look at is the Medical Treatment Planning Decisions Act of 2016, and this is my current role as the support officer for the new team at the Office of the Public Advocate. We've got 2 decision officers and 1 support officer. So under the new legislation, as of the 12th of March 2018, adults and children can make an advance care directive and they can appoint a support person for their medical treatment decisions. Only adults can appoint a medical treatment decision maker. Now the reason for that is that anyone that has parental rights over a child is presumed to be their medical treatment decision maker. So in Victoria, to make an advance care directive or either of these 2 appointments, a person must have decision-making capacity to do so, and the forms must be signed in front of 2 witnesses. So an advance care directive. Now the terminology is very important. Many people in the community will be thinking of advanced care planning, which is a commonly known phrase, but in regards to this new legislation, the terminology is advanced care directive, and an individual can only make an advanced care directive according to what's prescribed in the Medical Treatment Planning Decisions Act since the 12th of March this year. So an advanced care directive is a legal document that sets out a person's, it could be their preferences and values in what's called a values directive, and or in a binding instructions document that's called an instructional directive. And they're specific to medical treatment decisions that the person, in an event when they no longer have decision-making capacity, would either consent to or refuse medical treatment that's been offered. So the documents are only relevant to medical treatment. You can't put something in there about your financial affairs or your accommodation wishes. It's solely around medical treatment. So again, an advanced care directive, it's a legally binding instruction for future medical treatment in which an individual either consents to or refuses treatment. A values directive is a document that clarifies and indicates what an individual's values and preferences about their medical treatment and healthcare wants are. So it's to be considered by anyone that's going to be making a medical treatment decision on their behalf in the future. A values directive. So an individual, under an advanced care directive under this legislation, an individual could choose to make both of these documents or one or either. So, but they're voluntary things, so there's no one has to do this. It's only a choice. So a values directive is a statement of a person's preferences and values on the basis on which they would like any medical treatment decisions to be made on their behalf at a future time. It must be considered by their medical treatment decision maker, and I'll clarify that role a little bit further on. So an example of a values directive could be, in general, I prefer alternative therapies such as acupuncture and naturopathy to conventional medicine. However, I am not absolutely opposed to all Western medicine, and on occasions I have been known to take antibiotics to relieve unnecessary pain and suffering. If I should lose decision-making capacity, I request that my medical treatment decision maker, in making decisions on my behalf, take into account my preference for alternative therapies, but also my desire not to unduly suffer. So it's giving directions to an individual that's going to be making decisions on their behalf at a later stage on what they do value and what their preferences are in regards to their healthcare and their medical treatment. On the other hand, an instructional directive is a statement of a person's medical treatment decision in advance, and it's directed to the patient's health practitioner. It takes effect as if the person who'd made it had consented to or refused the commencement or continuation of the medical treatment themselves. So it's something that people, and again, we're not sure how many people will uptake an instructional directive, but it's something that people that have very strong definitive views on certain medical treatment may consider to do. An example of an instructional directive is I refuse any and all vaccinations for any purpose whatsoever, regardless of the reason for the vaccination being recommended, including if that was to mean I could no longer travel. So it's giving direction to a health practitioner that under no circumstances the individual would agree or consent to vaccinations. It's very important, though, that anyone that wants to undertake and make an instructional directive is very clear in their instructions and has a full understanding of how those instructions will be interpreted. An individual, for example, may say that under no circumstances do I ever want to be put on a machine that helps me breathe. Now, that can be interpreted in many ways. It may be that you don't want to be put on long-term ventilation, but it may also rule out the time when you need short-term surgery, you need surgery for a curative treatment, and you may need to have a full general anaesthetic during that procedure. So someone that's going to make such a statement in an instructional directive really needs to understand what the consequences of that statement's going to be for a health practitioner further down the track. So medical treatment decision makers, this is a new appointment under this legislation. A person, and only an adult, can appoint a medical treatment decision maker who has the authority to make medical treatment decisions on their behalf only when they do not have decision-making capacity to do so for themselves. And they must make the decision that they reasonably believe is the one that the patient would have made themselves. So again, it's that shift away from the best interest to actually putting yourself in the shoes of that individual and making a decision that you strongly believe they would have made themselves. So any medical treatment decision maker must follow Section 61 of the legislation and must consider the patient's values directive, if there is one, or any other values and preferences that the patient has expressed at any point in time. So they really have to look at it from the perspective of the individual that's appointed them. So we'd always encourage someone, if they're going to make an appointment for a medical treatment decision maker, not only do they inform that person that they're going to be appointed, but they have full discussions about what their healthcare preferences and what they value around medical treatment and healthcare are, so that that person has insight into what this individual does want. Another appointment under this legislation, and this is a very new appointment, is the support person role, and this may be of some interest. So this is the role where a person can be appointed to support a patient to make, communicate and give effect to their medical treatment decisions, and they can represent the interest of the patient in respect to the patient's medical treatment, including when... So this role, a support person, solely functions in their role when an individual still has decision-making capacity to make their own medical treatment decision. They're not medical treatment decision makers, so they can't make a medical treatment decision on behalf of an individual. Their role is solely to support. If, however, that individual loses capacity at some point in time, they still have a role in advocating for that individual. And importantly, the support person can access health information about the patient that is relevant to the current medical treatment decision. So they may be able to access the medical records. They could call the GP up after they've been to an appointment with the individual, and the person that's appointed them has become a little bit overwhelmed by all the discussion during that appointment. They would have legal authority to ring the GP at a later date and expand on those discussions so that they can help that individual to make their own decision. So it's solely a supportive role. Now, accessing information and with privacy restrictions may be something that someone really values, and so this might be a role that someone considers appointing. So Health Records Act and the Privacy and Data Protection Act requires consent from an authorised representative. The new Medical Treatment Planning Decisions Act would allow a medical treatment decision maker and a support person to be that authorised representative. Now, as with everything, there's legal requirements. So in making an advanced care directive or appointing a medical decision maker or support person, forms haven't been legislated, but the Department of Health and OPA have developed some forms. They're freely available on our website. They're in our publications, but there are formal requirements. So if someone chooses not to use the forms that have been created, then that's okay, but they need to make sure that they've done the formal requirements according to the legislation, otherwise it won't be a valid appointment or form. So the formal requirements are specific to witnessing, an advanced care directive. There are 2 witnesses required and 1 must be a registered medical practitioner. Now, we believe the understanding for that is, as I was saying before, an instructional directive. When someone puts in such a clear definitive statement, the registered medical practitioner will be able to unpack that with the individual before they sign off and witness it, to make sure they have a full understanding of what the connotations of such a statement would be in the future. For the appointment of a medical treatment decision maker or support person, again, there are 2 witnesses required. One of them can either be a registered medical practitioner, or else it could be someone that's authorised to witness affidavits, such as a Justice of the Peace or a practising lawyer. Oops. And again, we have all that information on our website, or please call the advice service and we can assist you. So medical consent. So as always, a health practitioner needs a patient's consent before providing medical treatment unless they are providing emergency treatment. The new Act sets out the medical consent process for a patient who does not have decision-making capacity to make the medical treatment decision. So from this point on, in regards to this legislation, it's solely around individuals who no longer have decision-making capacity. If an individual has decision-making capacity, and again it's decision-specific, they should be given the right to make their own decision. And some people may not have capacity to make a decision about an extensive surgical procedure, but they may have the ability to consent to a flu vaccination. So it's specific to the decision that's at hand. So the Act talks about, health practitioners, and it's a much broader group of professionals than was previously under the old Medical Treatment Act. So it not only includes medical and dental professionals, but it also includes physiotherapy, podiatry, nursing, midwifery, medical radiation practice. Importantly, it doesn't include dietitians, speech pathologists or social workers. But in regards to a speech pathologist, if what they're proposing to do or the treatment they're proposing to offer to a patient fits the definition of medical treatment under this legislation, even though they don't fit the definition of a health practitioner, they should get a colleague that does fit the definition of a health practitioner to seek consent on behalf of that patient. So any medical treatment needs consent unless it's emergency treatment. And again, this is a lot of information to take in an hour session, but please feel free to contact the advice service or look on our website. So the definition of medical treatment, under this legislation there are two components, and importantly it has to meet one part in each component. So it must be a purpose of treatment. So it must be either for diagnosing a physical or mental condition, preventing disease, restoring or replacing bodily function, or improving comfort and quality of life. And then it must also fit under the form of treatment. So it must fit under either treatment for physical or surgical therapy, treatment for mental illness, treatment with prescription pharmaceuticals or an approved medicinal cannabis product, dental treatment and palliative care. Now, under this new legislation, pharmaceuticals now fit as defined as medical treatment. So anyone that can provide their own consent should obviously be doing so, but an individual that doesn't have decision-making capacity, someone needs to give consent for prescription pharmaceuticals. However, a compulsory patient under the Mental Health Act is a person who is on a compulsory treatment order. They would fit under the Mental Health Act and not under the Medical Treatment Planning Decisions Act. Emergency treatment. Medical treatment or a medical research procedure that is necessary as a matter of urgency to save the patient's life or prevent serious damage to the patient's health or prevent the patient from suffering or continuing to suffer significant pain or distress. The reason I'm emphasising the or is a lot of health practitioners stop at the first line, and if they don't feel that it's to save their life immediately, they would not deem it as emergency treatment. So often we'll get inquiries at the office. We just unpack that situation with them. But it is a clinical determination if treatment that's being offered is emergency treatment. Now, a health practitioner does not require consent to provide emergency treatment as long as they're not aware that the individual has refused that treatment in either an advanced care directive, such as an instructional directive, or in a previously made refusal of treatment certificate. So that would still be a valid certificate if it was made prior to the 12th of March. So if a patient has refused the treatment, then the health practitioner wouldn't proceed. An instructional directive in emergency treatment. If emergency treatment is needed, a health practitioner is not required to search for a directive that is not readily available. So that's something that is very important for health practitioners. I'm sorry, I keep making noise with that thing. So obtaining a medical treatment decision. The slides originally for this legislation are quite extensive, but I've condensed this down, so I hope this makes sense. So in obtaining the medical treatment decision, the legislation sets out 3 steps for health practitioners to follow. It may be that you're not actually a health practitioner, but you're advocating for an individual that has been offered some medical treatment, or you're involved with a client that needs medical treatment. So just familiarising yourself with the fact that there are steps that health practitioners can follow so that an individual who does not have decision-making capacity should never miss out on receiving appropriate medical treatment. So the 3 steps, I'll go through those in a moment, but the definition of a medical treatment decision is either to consent to the proposed commencement or continuation of the medical treatment, or refuse the commencement or continuation of medical treatment. Under this legislation, a medical treatment decision maker can be appointed, but anyone that's appointed previously an enduring power of attorney for personal matters under the Powers of Attorney Act, or a enduring guardian under the Guardianship and Administration Act, if they had healthcare authority, then they would now be deemed the medical treatment decision maker for the individual, and they have legal authority to either consent to medical treatment or refuse medical treatment when a person no longer has decision-making capacity themselves. So So this is the shortened version, the flow chart, on what a health practitioner needs to follow. So the first thing a health practitioner needs to do when they've got an individual in front of them that does not have decision-making capacity to consent to their own treatment is to find out whether that individual has made an advanced care directive. Now again, it's about the terminology. It's not an advanced care plan, it's an advanced care directive that can only have been made as of the 12th of March of this year. So if there is an advanced care directive with a relevant instructional directive and the individual has refused the treatment that's being proposed in that document, then the health practitioner withholds or withdraws that medical treatment. Now again, we're not talking about emergency situations. If the patient has consented to that particular medical treatment in their instructional directive, then the health practitioner would proceed to administer that medical treatment if they were of the opinion that it was clinically appropriate to do so. So nothing an individual can document in an advanced care directive can compel a health practitioner to offer medical treatment. That's a clinical determination and that's for them to make. If the health practitioner at any stage has any concerns or questions the validity or the meaning of a directive, then VCAT's the appropriate body for them to seek advice from. And again, refusal of treatment certificates are valid. The next step, so if there's no advanced care directive, then the health practitioner moves on to step number 2. Is there a medical treatment decision maker for this individual? There's a hierarchical list. I'm not sure if you're familiar with the old Section 42K or the person responsible list that was in the Guardianship administration. It's a new hierarchical list. It's been a little bit condensed and narrowed, but the first person on that list, and again this information is available on our website, is the person's appointed medical treatment decision maker. So that's not only a person that's been appointed under this legislation as a medical treatment decision maker, it could be an enduring power of attorney for personal matters if they had healthcare authority, and or an enduring guardian, or the old enduring power of attorney for medical treatment, which has been repealed since the implementation of this legislation. Secondly on that list is a guardian appointed through VCAT who has the authority to make medical treatment decisions. If no one fits those categories, the health practitioner moves down to number 3, which is the first person in the following who's in a close and continuing relation. Now again, the terminology of close and continuing relation has been added to this legislation specifically to weed out families and relatives that have come, have not had anything to do with the individual for decades, and to step in and make decisions when they're needed. So first it's a spouse, domestic partner, then it moves down to a primary carer of the patient, then it moves down to an adult child of the patient, a parent of the patient, or an adult sibling of the patient. Again, they've removed aunts, uncles and nieces and nephews just to try and narrow that category and make sure it's an individual that does have a close and continuing relationship. If there is a medical treatment decision maker, then the health practitioner goes to the medical treatment decision maker for that medical treatment decision. And that medical treatment decision maker can either consent to that treatment or they can refuse that treatment. If there is no medical treatment decision maker, then the health practitioner would proceed to step 3, which is where they need to make the distinguishing clarification on whether the treatment they're offering is routine treatment or significant treatment. Up until that point, it doesn't matter. If they're offering medical treatment, then they need consent, unless it's an emergency. So if the treatment they're offering is routine treatment, then a health practitioner can undertake that treatment without consent as long as they meet their recording obligations in the patient's clinical records. In the legislation, routine treatment's defined as anything that's not significant treatment. But significant treatment has been clearly defined as anything that has a significant degree of bodily intrusion, a significant risk to the patient, causes significant side effects and or causes significant distress to patients. Now this is where it might be quite relevant to everyone in the audience. What's routine treatment to me or to you may not be routine treatment to an individual that's got complex mental health needs or a cognitive disability. The health practitioner needs to look at the individual and look at the circumstances that are presenting. They can't just say, oh, this is routine to me, I offer it all the time. I'm used to taking out teeth, say if it's a dentist. They've got to look at who's in front of them, who they're offering the treatment to, and it may be that it's significant treatment for that individual because it may cause them significant distress. So it's based on each presenting circumstance. All right, I've bored you enough with the Medical Treatment Planning Decisions Act, so we'll move on to the Powers of Attorney Act. So, powers of attorney are legal documents where an adult and who has decision-making capacity, and they're called the principal, gives another adult with capacity, the attorney, the power to make decisions for them or support them to make their own decisions. Powers of attorney operate while the principal is alive and wants or needs someone else to assist them with decision-making. When the principal dies, the authority ceases. Every state and territory in Australia has its own laws in regards to powers of attorney. An enduring power of attorney is a legal document that lets someone appoint someone else to make decisions on their behalf, and it endures, so it continues after that individual has lost decision-making capacity. Now, a principal, so the person that's making the appointment, can appoint whoever they choose, the attorney, and they can appoint them to make decisions around whatever matters of their choosing, and they can commence at whatever time of their choosing under the powers of attorney legislation. So you can make a powers of attorney if you're over the age of 18 in Victoria and you have decision-making capacity to do so. You can only make an enduring power of attorney appointment for yourself and not on behalf of anyone else. I'm staggered at the number of calls we get on the advice service asking whether individuals can make a powers of attorney appointment for their parents who no longer have decision-making capacity to do so. So if a principal is able to make their own decisions and they've made a enduring power of attorney appointment, then the principal oversees the use of that power, and the person that they've appointed, the attorney, acts at their direction. When the principal loses decision-making capacity, that's when the attorney needs to act and make decisions in the best interest of the principal. So an attorney, importantly, prior to the 12th of March, an enduring power of attorney for personal matters did include healthcare matters, but post 12th of March, there's no longer healthcare matters that can be included. So if someone wants to appoint someone to have authority to make medical treatment decisions, they need to appoint them as a medical treatment decision maker under the Medical Treatment Planning and Decisions Act. Now, other than enduring powers of attorney, there's non-enduring powers of attorney, the general non-enduring power of attorney, and that becomes invalid the minute the principal loses capacity. So it's often something that an individual might decide to do if they just need someone to make a financial transaction on their behalf whilst they're overseas, or undertake short-term banking for them when they can't actually access that themselves. So, another appointment that can be made under the Powers of Attorney Act is a supportive attorney appointment. And this promotes the rights and autonomy and dignity of an individual and allows an individual to appoint another person to assist them in making decisions around personal matters, financial matters, or both, or any matter that they specify. So it's about the individual, the principal, making their own decisions and just having formal support by their supportive attorney. There are 3 powers that a supportive attorney can undertake, and that can be all or any of information power, communication power, or power to give effect to decisions. So a supportive attorney appointment has no effect during a time when the principal has not got decision-making capacity. Some people will undertake these appointments because of a disability, or others may undertake it because they know they're hitting a time in their life where they've got a severe illness or a severe injury has occurred and they just want that additional support and they want it to be formalised. Okay. I'll just clarify this, sorry. So a supportive attorney gives authority not only to undertake the information power, the communication power, and to give effect to a decision, but they can also get involved in collecting information that's relevant to that decision. So again, it could be an appointment that's assistive if someone gets very distressed or confused in appointments, or doesn't like communicating with banks or Centrelink. If they appoint someone to be their supportive attorney, they've actually got that legal authority to access that information that's relevant to the issue at hand. So again, it can assist with privacy issues. Okay, so now we'll move on to the Guardianship Administration Act. So the Victorian Civil and Administrative Tribunal, VCAT, is the authority that has the jurisdiction over the Guardianship Administration Act, and they have what's called a guardianship list. And the mission of the guardianship list is to protect the personal and financial affairs of adults with disability who are unable to make reasonable decisions about their person, circumstances or affairs. The role of a guardian or administrator is to protect people aged over 18 as a result of their disability who are unable to make reasonable decisions about themselves and their circumstances, as I said. Guardianship is deemed to be last resort, as should be administration. If there is no less restrictive alternative to safeguard the interests of the individual with a disability, then that's where guardianship and or administration will come into play. As I said earlier, all adults have the right to make their own decisions, and people with disability should be encouraged and supported to make their own decisions. However, if a person is unable to make reasonable judgments because of their disability, and there are concerns about the decisions they are making or that others are making for them, then VCAT can appoint a guardian or an administrator to make decisions on their behalf. But VCAT need to be satisfied that it's the right thing for the individual. Guardianship may also be needed if there are differing views that can't be resolved in a less restrictive manner. So it may be that the individual has a severe cognitive disability, they aren't able to make their own decisions, and there's a person that's been appointed as an enduring power of attorney for personal matters, and they have authority to be making an accommodation decision on mum or dad's behalf, and there's massive conflict amongst family members in regards to that. So VCAT have the authority, they can review that power of attorney appointment, but they can also decide, if they feel it's in the best interest of the individual, to appoint a guardian to have that authority. And it may be that they appoint the family member, or it may be that they appoint an independent guardian who would come from our office. So they'd appoint the public advocate. Administration solely around financial affairs. So the role of the guardian. VCAT can hear applications and make orders in regards to appointing guardians and administrators for up to 3 years. It safeguards the operation of enduring powers of attorneys also, and supportive attorney appointments. And VCAT also have the authority to consent to special procedures. And anyone with a special interest in an individual or concern about their welfare can make an application to VCAT and can express their concerns regarding decisions that are needing to be made for that individual that has a disability. So the Guardianship Administration legislation specifically talks about an individual with a disability. The Powers of Attorney Act and the Medical Treatment Planning Decisions Act talks about decision-making capacity. So VCAT also have the authority to make orders in regards to the Medical Treatment Planning Decisions Act. So under the guardianship list, VCAT protects a person 18 years or over as a result of a disability who is unable to make the decision. They can, the definition of disability in the Guardianship Administration Act is an intellectual impairment, a mental disorder, brain injury, physical disability or dementia. So it's broad range. VCAT also have the jurisdiction for special procedures. So these are procedures, medical treatment, that would possibly cause permanent infertility, the termination of a pregnancy, or the removal of tissue for transplant. So this is the process. If someone was concerned about an individual and they put forward, we would always encourage anyone that has concerns about an individual not having the ability to make reasoned decisions for themselves to contact the advice service and to unpack the concerns and the issues so that we could try to direct you whether guardianship would be appropriate or administration, or whether there are less restrictive options available for that individual. Guardianship and administration should always be seen as last resort. An applicant would put forward a VCAT application, and then there may very well be a need for an investigation. VCAT will determine that, and that would come from our office. If there's no need for that, then VCAT would set a hearing date. The individual and all interested parties would attend that hearing, and then it would be up to VCAT to determine whether it is in the best interest of that individual, and there's no less restrictive means to appoint a guardian or an administrator. If they choose to appoint a guardian, they can appoint a private guardian. As I said before, that could be a family member, it could be a close friend, or if there's no one that's appropriate that fits that, then they could appoint the public advocate. Now, a guardianship order can be limited to decision-making authority for healthcare and or accommodation and or access to persons and or access to services, or it can be a plenary order that encompasses all of those. An administration order is solely around financial and legal decisions. So again, when is a guardian or administrator needed? It's going to come down to the person has to be over the age of 18 and they must have a disability. They cannot make reasonable judgments because of that disability. They need to make a decision, so it needs to be relevant to the decision at hand. It can't be made preemptively for future use. And there needs to be someone that can act in their best interest. Okay, so VCAT also have the authority to make temporary urgent orders, and they do try to hear these orders, these applications as soon as possible. We would always encourage people again during business hours, if you feel that someone requires an urgent or emergency order, please, if there is time, ring our office first to unpack the situation. It's very restrictive and it really should be seen as last resort and only in emergency situations, because there's no hearing for a temporary urgent order, and it can be only made for 21 days and it can be extended again. So guardianship, and a guardian, if one is appointed, will be an advocate, will protect an individual from abuse and exploitation and neglect, will respect family relationships, culture and confidentiality, will always try to consider the wishes and the least restrictive options for that individual, and will consult with anyone who has a real interest in the well-being of the individual. Now, a guardian can be someone that's been appointed who is a family or friend, or, as I said before, as a last resort, it's from the public advocate's appointed and one of her delegates will undertake that role. Now, VCAT have the disability jurisdiction for all these legislative acts. So for Guardianship and Administration Act, for the Powers of Attorney Act, the Medical Treatment Act of 1988, which has since been repealed, the Instruments Act of 1958, which again has been repealed, the Disability Act, the Medical Treatment Planning Decisions Act, and their own Victorian Civil and Administrative Act. Okay, and for more information, as I said before, I'd strongly recommend that not only do you ring our advice service, but you look on our website and navigate through it, or the publications, and I've got many publications out in the foyer. So I have raced through that, and I do apologise, but 3 legislative acts in an hour is a big ask. So, any questions? Yes.
Is that on? Yeah. Hi, I'm actually a parent of a young man who's 21 with reduced capacity and was born that way. So you actually didn't touch on this group, which is very problematic when they turn 18. I am his nominee under several jurisdictions, as in Centrelink, the NDIS.
Okay, yep.
And Medicare have just brought out nominee forms only in the last couple of months, which I've submitted and I'm still waiting. But the problem is with the banking sector still. And I've had a big problem with them. I had to go to the Financial Ombudsman to get something, but they're claiming they'll only accept guardianship, only accept administrative order, which I'm not prepared to do because I don't see.
Powers of attorney.
Because he can't give powers of attorney.
I know,
right?
and they don't.
And this is a real problem. To me, it's discriminatory. The state doesn't look after yours and my money. Why should it look after David's? And they admitted that I've been looking after his money properly. I've since changed banks, and it all has to now be put in my name. It shouldn't be like that because it's not my money, it's his. What are you doing for this group who have never got the... He can decide what he wants to eat, what he wants to wear every day, but he can't make these big...
Yeah, it's not an
big,
uncommon issue, it really isn't.
Is there anything we've moved on this?
On the advice service, we will always encourage parents in your situation to push back on the bank and to say you can't discriminate, that's right. If they stand their ground, then really it is the financial ombudsman. But the office does work to advocate systemically and try to make change, but at this point in time, I haven't heard of anything that fits that category.
No, it
of
hasn't.
client.
And even the
No.
financial ombudsman, it wasn't
They're limited
about...
in what they can
They
do.
are limited, and it wasn't about making them pick their act up and behave properly and non-discriminatory. It was purely to get the accounts closed when I emptied them. That's what I had to go to the ombudsman to get done, because Westpac, and I'll name them, actually wouldn't even do that. Within 24 hours, oh, we've changed our mind, yes, we'll do it. How ridiculous.
I agree, and like I said, it's not uncommon, and I'm really sorry that you've experienced
But
that.
what is progressed in
well,
relation to this group? Because we can't keep going down this road. We're in 2018.
I'll take it back to the office and certainly
I rang your
express-
office about it, and they kind of talked about, making them accountable.
And
they
that's-
won't go there.
Yeah, and that's
why
what
they're
we
in a
always
royal
try. But some people do have success with that. I've had a few where I've had callers come back to me saying that as soon as I mentioned the word discrimination, they actually opened a few doors, but they were the lucky ones. We are very aware it's an issue, and I will certainly take it back to the office. But I do apologise, I don't have an answer for you today. But I will take it back. Anyone else? Surely there must be a question. And Jimmy, you're not allowed to ask. No one?
How much money?
Sorry?
Is there money still coming through to help people who are needing it, who have a disability? Because I know a lot of people are still saying that the money's not coming through and they do need it.
I'm sorry, money from where though? I work at the Office of the
Right.
Public Advocate. We don't deal with anyone's financial affairs.
You don't?
No, it would be if you're talking about it, it would be an administration
Right.
order, and it would be determining based on who VCAT have appointed to be the administrator. So if someone's having difficulties and they're under an administration order and VCAT have appointed someone, then I would suggest that those inquiries go directly to them. Unfortunately, I can't answer that question.
All right?
Sorry.
Once
But
I just answer
If VCAT make an order and appoint our office, appoint the public advocate, it's solely for guardianship matters. We don't
Right,
deal
so
with
it will
financial.
all
We can
do-
certainly give advice on the advice service if you want to ring, and the advice and education officer could talk to you about your specific issue and try to help you unpack it and give you a pathway forward. But I can't at this point, sorry.
Well, I mean, it's interesting to know these. It is interesting to know these things, and I know a lot of people are complaining about the NDIS and not getting that money through.
Yeah.
And still, there are many people who are not receiving that package.
Okay. Yeah, no, again, that's not an uncommon circumstance, and I'm sorry to hear that. But by all means, please ring the advice service and we can try and help you specifically to your individual circumstances.
Well, I hear these things. Maybe I'll ask a few people from the Office of Disability, because I know some of them are here.
Okay.
So are there any more questions? No? Okay, thank you very much, Sharon.